The learned counsel appearing on behalf of the appellants could not deny the fact that the total number of petitioners concerned in these acquisition proceedings coming up before the High Court was extremely insignificant as compared to those who had accepted the compensation. Of course, that by itself may not be the only reason to hold against the appellants within bracket petitioners. However, that fact will have to be kept in mind while deciding the issues which cover the whole acquisition process, which acquisition is for the purpose of development of 25 million square meters of land. The High Court has also noticed this aspect. We have mentioned this aspect only with a limited objective of showing that the criticism against the whole scheme which would invalidate the acquisition would be difficult to be accepted, particularly in this case, in view of the fact that majority of the landowners have parted with possession, taken the compensation, and thus, the whole scheme has progressed to a substantial level, wherefrom it will be extremely difficult now to turn back to square one. The expressway is a work of immense public importance. The state gains advantages from the construction of an expressway, and so does the general public. Creation of a corridor for fast-moving traffic resulting into curtailing the traveling time, as also the transport of the goods, would be some factors which speak in favor of the project being for the public purpose. Much was stated about the 25 million square meters of land being acquired for the 5 parcels of land. In fact, in our opinion, as has rightly been commented upon by the High Court, the creation of the 5 zones for industry, residence, amusement, etc., would be complementary to the creation of the expressway. It cannot be forgotten that the creation of land parcels would give impetus to the industrial development of the state, creating more jobs and helping the economy, and thereby helping the general public. There can be no doubt that the implementation of the project would result in coming into existence of 5 developed parcels canters in the state for the use of the citizens. There shall, thus, be the planned development of this otherwise industrially backward area. The creation of these 5 parcels will certainly help the maximum utilization of the expressway, and the existence of an expressway for the fast-moving traffic would help the industrial culture created in the 5 parcels. Thus, both will be complementary to each other and can be viewed as parts of an integral scheme. Therefore, it cannot be said that it is not a public purpose. The respondents, on the other hand, argued that there was material available before the government justifying the invocation of the urgency clause. The respondents argued that, in fact, the High Court has returned the finding that there was material before the state government for dispensing with the inquiry under Section 5am of the Act, and that finding was based on the examination by the High Court of the records of the state government.